think I saw you yesterday. Yeah. Yeah, I was hanging out. I was walking,
Are you writing him too?
Yeah, hanging out. But of course, the docs.
Your eyes light up. Really good. Imagine you didn't realize you're like a full green out.
I don't know. I'm kind of against giving dogs people. I think you should name them like crazy stuff, like lost a nail, your screw, it's tape.
See Rutherford? I swear I've seen so many. Yeah, it's always like a double mess. I think Mark is a good dog.
Bro, at this point,
All right, good morning. Good morning. Good afternoon. We're pretty much done. We are at the end. So class today, class Wednesday, and that's all, folks. We'll do a review, I think, on the 8th, and that's it. As a general rule, again, your review session is on the 8th, right? And your exam is the 9th or the 10th? Hold on. 10th. So my usual rule is 48 hours for the exam for cutoff. That's fair? So any questions? No later than the review session. Or at least my office after that, okay? I find that as you get closer to the exam, the quality of the questions decrease and the level of panic increases. And students start panicking and they're like, can you teach me the entire class again today? And I'm like, I can't do that. It took me, 3 months, if that. So cut off before the exam. Any questions in general of things that might be on your mind? No? Okay. So let's recap last class. Last class, we covered Roe v. Wade. And Roe established a fairly easy to describe regime for abortion, right? Whatever its criticism, it was clear. You knew exactly what it was. And what was the rule in Roe? We got this trimester framework. And you don't have kids, you don't know about this, but pregnancy takes roughly 9 months, give or take. A trimester, it's like a third. So you divide the pregnancy into 3 months. The rule in Roe is like this. In the first trimester, that's the first 3 months, the state's power was virtually limited over abortion. They could regulate doctors, which they can always do. And that's about it. They cannot impose any laws that are designed to protect the life of the fetus. Zero. Nothing. So, in effect, you had no abortion restrictions in the first 3 months. Then in months 4, 5, and 6, the second trimester, the government had a little more leeway. They might be concerned that abortions may be harmful to the mother's health, and they could restrict them. But again, it was for the mother's health, not for the life of the fetus. Under Roe, it wasn't until the point of the third trimester, the last 3 months, that they can actually restrict abortion to promote human life. But even then, there were exceptions for the health, for the life and health of the mother. And health was defined quite broadly to include everything from mental health to gestational diabetes to basically anything. So Roe, for all of its trappings, made it illegal to restrict abortion at the first 6 months, pretty much, and almost entirely during the last 3 months, subject to health and safety regulations, right? Everyone sort of get the regime. Roe didn't talk much about viability. I want to just mention that now because it was relevant in Casey and also in Dobbs. Viability is largely defined as the point at which a fetus can be delivered and survive outside the mother's womb, right? As you might guess, science changes this number. The point of viability in the 1970s is different than the point of viability in the 1990s, which is different than the point of viability today. Today, it's not uncommon that a woman going to labor at the 6th month and the baby survives. Someone can Google this, but I know even at 5 months it's possible, and maybe not much before that, but I think 5 months is about the limit of science right now. But Roe didn't focus much on viability. That would come into play in the Casey case about 20 years later. Someone asked me last week, is Roe strict scrutiny? It doesn't use that label, but I don't know the way to describe it. Roe explains that there's a fundamental right, and generally the fundamental right, you apply strict scrutiny. Casey would sort of dispute that, but at least the law after Roe is strict scrutiny is afforded. Okay, everyone get the Roe framework. Again, it's agree or disagree, it's actually easy to say. I can say within 2 minutes. Yes, Oscar.
For fundamental rights, that is the substantive due process test.
This is all substantive due process, right? But with substantive due process, we have to be very fundamental or not. If it's a non-fundamental right, you give it a rational basis standard. And if the right is fundamental, you give it a something more than rational basis. That's what we discussed. Good.
Rational basis under the opposite.
Pretty much. It's not, the optical is an equal protection case, but it's more or less, if there's any basis on which this law can survive, it's valid. But as we'll see today, the court doesn't always apply that law consistently. In law in some of the cases. Okay, so everyone get Roe. So what happened after Roe? A lot happened after Roe. So leading up to Roe, and I know this is sort of hard for you all to believe or at least understand, abortion was not a very controversial topic, at least as it was today. Many mainstream religious groups, even the Southern Baptists, were basically moving towards liberalizing abortion views. But Roe, if not right away, shortly thereafter, had a backlash where Christian evangelicals in particular said, wait a minute, we need to protect life. And the Supreme Court's getting in the way of this. An entire political movement was born on the mantra of we must overrule Roe. And on the other side, an entire political movement grew on to say we must save Roe, we must keep Roe. And almost every election became a referendum on abortion. In fact, President Reagan's election in 1980 is due perhaps in large part to the abortion issue. And you can see the numbers on this. There's actually very good statistics on this. And when President Reagan came to office, he pledged to basically appoint Supreme Court justices who would overrule Roe. On that ground, he's not doing a very good job. Neither did President George H.W. Bush. That's what happened. President Reagan made his first appointment to the court as Sandra Day O'Connor. He had said he wants to appoint a woman to the court, and he did that. And how did he pick O'Connor? As we know now, he picked William Rehnquist's old girlfriend. And Rehnquist apparently recommended O'Connor. The second pick was Justice Antonin Scalia. And this might be surprising. Scalia was actually viewed as a bit of a diversity pick. What? He was Italian. It was a big deal to have an Italian American in the court. All these Democrats who were Italians in the sense of we are so proud to have an Italian on the court. Can you imagine that today? Almost like we have like 2 Italians like in the Tri-State area in the court right now. It was viewed as a very big deal. The third seat would prove to be most controversial. Originally, President Reagan nominated Robert Bork to the Supreme Court. Have you heard the name Robert Bork? No. Well, you should. I talked about it in the semester. In Morris against Olson, he was the acting attorney general who fired the special prosecutor. Oh. Later in his career, Bork would become a federal appellate judge in D.C. And Reagan tapped him for his third seat to the court to replace Justice Powell. Remember the Bakke moderate? The Democrats blocked Bork's nomination. This really had never happened before like this. Happened in other ways, but not like this. They said that Robert Bork would bring us back days of back alley abortions, he'd overrule Roe v. Wade. They went all out and they blocked his nomination to the court. Reagan made a second attempt to fill the seat with Douglas Ginsburg, who was a federal judge in D.C. This is going to seem quaint by modern standards, but he was a professor at Harvard. He apparently smoked pot with some of his students, and that was disqualifying in the 80s. Today, that'd be an asset for many nominees. He was actually my professor in law school. Brilliant guy. He's still alive and active, which was on the Supreme Court. But instead, we got the backup. Ronald Reagan was from California. He had two of his Supreme Court nominees go down in flames. He said, oh, we need someone who will just get through, confirm someone. And who did he pick? A moderate from Sacramento, Anthony Kennedy. So the reason why we got Anthony Kennedy was because the other two nominees failed. And that would be the Reagan noms. Fast forward to the Bush administration. George H.W. Bush had two appointments in his first term. First was William Brennan, the liberal lion. George H.W. Bush could have filled the Brennan seat with a Republican appointee. Could have changed the world, literally. And who did he pick? Well, he could have picked Edith Jones, whose office is down the block and still down the block. He did not pick Judge Jones. The worst decisions ever made by Bush, and that's saying a lot. There was some really bad Bush decisions. That's one of his worst. Either one. He picked David Souter. David Souter was a moderate from New Hampshire who had been a federal judge for 5 minutes. Didn't really do very much, but his Bush's chief of staff said, "Don't worry, this guy's solid. He'll be great." And Souter proved to be a fairly consistent liberal. But then the Thurgood Marshall seat opened up. And George H.W. Bush picked Clarence Thomas for the seat. Now, I'm convinced if Bush knew how conservative Thomas was, he wouldn't have picked him. I'm because he had no idea what he was getting himself into. Thomas's first opinion on the bench was a dissent. I think it was a solo dissent also. He was ready from day one. But that brings us to the Casey Court. When Casey was decided, if you can imagine this, there were 8 Republican appointees in the Supreme Court. 8. There was one Democrat appointee, Byron White, who dissented in Roe. There were 8 Republican appointees, and what was the vote in Casey? 5-4 to reaffirm Roe. If you want to sort of think about why there such a movement on trying to pick more conservative judges, Casey was the moment. That despite having 5 Supreme Court picks in a decade, 3 of those vote to reaffirm Roe, despite everything that happened. So this is in large part why the Federal Society exists, is to change a culture that never, ever, ever happens again. And didn't, although Chief Justice Roberts couldn't bite the bullet and overrule Roe and Dobbs and do it. So that brings us to Casey. Okay. This is probably the last time I'll teach Casey in any sort of depth. I'm actually editing the case book with Randy now. The excerpt of Casey is going to be like 10 pages long. It's going to be tiny. And the excerpt of Lawrence is going to be like 15 pages. And Obergefell is maybe like 10. So this entire unit is getting compressed down in half. This just doesn't really matter to us. You were my swan song. You're the last time I do this. But we'll make it count. Throughout the 1980s, states began to experiment with abortion laws. They said, okay, look, Roe said that we can't make restrictions during the first trimester. We really can't make any restrictions in the second trimester. We can ban the third. But let's try to do other things, right? Let's not ban abortion. Let's just make it harder to get one. So they would, for example, look at the Pennsylvania law. Right? What did Pennsylvania do? Pennsylvania said that if a pregnant woman's married, or if a married woman's pregnant, say like that, if a married woman's pregnant, she must notify her husband before she gets an abortion. She doesn't have to get permission, just to notify him. Thinking was that perhaps the husband has some interest in whether the child is aborted. Right? That was the interest of the state. Other laws were, for example, you must obtain a sonogram before you have an abortion. You must provide informed consent, that is information about adoption, other things before you have an abortion. Right? In other words, they weren't banning it. They were making it perhaps harder for the woman to obtain it, either through guilt or pressure or otherwise. So the states started getting very crafty. I was saying, look, we're not banning it. We're just putting obstacles in the way of having an abortion. And this led to the Casey decision, right? This is what sort of led to the case itself. Who was Casey? Casey was actually the governor of Pennsylvania. His son is now the senator. Oh, was the senator of Pennsylvania. He lost his seat last election. Okay. Everyone with me? Okay. So who am I up to? No one? No one even remembers. So, sure, why not? You want to go? All right, so Sean, let me ask this question. The very first sentence in the opinion in Casey, liberty finds no refuge in a jurisprudence of doubt. Liberty finds no refuge in a jurisprudence of doubt. It's like burning to my retina, that sentence. Can't forget it. What does that mean?
Well, I thought it meant that jurisprudence that is goes back and forth and has no clear line or expectation is always correct.
So what is necessary then for liberty to not be in doubt, according to Justice Kennedy?
I think it's like some clear lines on what the judicial branch can and cannot have.
So certainty, stability. Okay. Casey is as much a decision about substantive due process as a decision about stare decisis and precedent. In other words, the Casey court may not have decided Roe v. Wade had they been the court in the 1970s. But by the time we get to the 1990s, they're saying we can't change course. One of the ironies of Casey is they do exactly that. They change course. All right, so let's take a step back. In the 80s, the Reagan administration was urging the Supreme Court to overrule Roe v. Wade over and over again. And the Supreme Court came close to overruling, but they didn't quite do it. Then you get to Casey, where the lawyer for Planned Parenthood said very clearly, if you uphold this statute, this Pennsylvania law, you have to overrule Roe. In other words, there's no way to uphold this law without overruling Roe. At the conference, when they voted in Casey, the vote was 5-4 to overrule Roe. There were 5 votes to overrule Roe. Justice Kennedy joined the court's conservatives to overrule Roe. But then, as things happen, the vote shifted. Not familiar? Much like the Obamacare case, right? The vote shifted. There's a great story, which is probably true, where apparently Justice Kennedy and Justice Scalia are neighbors. They actually live, or I don't still live here, but at least they live very close to each other, Virginia. And Kennedy and Scalia were talking, and Scalia's like, Tony, is everything okay? Is there, are you solid? Don't worry, I'm there. I'm there. And the very next day, apparently Kennedy went to work and started making plans to defect and leave the majority. Justice Kennedy decided to write a joint opinion with Justice O'Connor and Souter. Now, what's a joint opinion? Usually an opinion is written by one justice, the other ones join it, right? Here, all 3 of them wrote it. And there are basically 3 primary parts of the joint opinion, right? The first is basically saying we can't overrule Roe. And I'll get to that in a minute. The second saying is, but we will reaffirm only the central holding of Roe. So we're not going to overrule Roe, but we'll get rid of parts that we don't want anymore. And then they apply that sort of new test, what's called the undue burden test, to the Pennsylvania law, where they uphold most of it, but not the husband notification provision. Everyone with me? Let's actually do the stare decisis part first. I don't know if I start there and back here. Conrad, I think you're next. Conrad, what is stare decisis?
That just means basically doing what you did before.
Right, stare, stand, decision, decisis, right? You're standing by the decisions of the court. Conrad, let me ask you a follow-up question, please. Why does the court, the Supreme Court at least, follow a doctrine of stare decisis?
Because they want the idea of they want people to expect things to be the same to create like a stable environment so people can trust the courts.
Okay, good. There are many sort of rationales for stare decisis. But one that Conrad mentioned I want to talk about is trust. In other words, imagine, every time a new member of the court's appointed, all new decisions come out. What might people think about the court then? That it's not behaving as if it's a court, it's behaving as if it's a legislature, right? The same way that when a house turns from Republican to Democrat or Democrat to Republican, they have new priorities, right? Stare decisis is one way to sort of negate that perception. Justices are simply politicians. Bobby, what's another reason why the courts might adhere to stare decisis?
I mean, if you're interpreting the actual text of the Constitution, that really wouldn't change.
Oh, that's a good answer, yeah. So if we are being faithful reading, giving the Constitution a faithful read, nothing's changed. In other words, the Constitution means the same thing today as it meant 50 years ago, right? So why would anything change? That works with historical analysis, though. I'm not sure if that works with the sort of the modern emerging awareness test, but that's a good answer. So, Brian, let me ask you one last question, right? If the court does not adhere to stare decisis, at least according to the Casey plurality, if they overrule precedents, what effect might that have both in the country and the court?
I mean, it goes back to what Conrad said about the stability of the court, and then obviously they would lose public trust.
Okay, public trust. Why would they lose public trust?
They're just changing the decisions every time, different facts arise. What do their opinions really mean?
But let's go one step further. If the public loses trust in the courts, what happens then? Why does that matter? Why do you trust in the courts?
Who would you trust otherwise? It kind of erodes the checks and balances, system of checks and balances and separation of powers.
Chelsea, what happens if people stop trusting courts?
They will take matters in their own.
Ooh, what do you mean?
They start to decide the law. Like I think of the movie. What was that movie? The Purge.
Oh, The Purge. I had a final exam question at The Purge one year. That was actually one of my exam questions.
And so they will begin to go and create their own law and order if the one system has to focus.
Everyone what The Purge is? It's like a horror movie, and the premise is like every year for like one 24-hour period, and the laws are not enforced at all. You can do whatever the hell you want. There are no consequences. And basically, everyone gets murdered. You know they actually film others in Staten Island, my hometown? It's not. It wasn't on the Better Purchase. Yeah, my exam question one year was basically they suspended the murder statute for 24 hours. It was a legal protection violation. It was actually a very hard question. People hated me that year. They usually do. You'll hate me in like 10 days. You believe that? Oh my god! Oh my goodness! I try so hard. You'll hate me. It's okay. I believe you. I believe you. Okay, but I think Chelsea makes a fair point. We often talk about why do people follow courts? The courts have not the power of the sword, they have the power of the purse. They're the power of their judgment. And if the court's judgment is viewed as being just another political branch, then they should be treated as such. So the Casey plurality, I'm sorry, I call it the joint opinion better than plurality. The Casey joint opinion, I think makes some fair points about legitimacy and the courts. Chief Justice Rehnquist, in response, and Justice Scalia says, that's all well and good until you actually think about what the precedent is, right? If we start and say, whatever the Warren Court, the Berg Court, you guys stick with that forever, that's a real easy thing to say. But if those original decisions themselves were not legitimate, in other words, what if Roe itself was something that erodes trust in the courts? And if overruling Roe restores trust in the courts. We'll get to the issue again in Dobbs. I don't want to do too much here. Anyone else want to add something to that? But just this becomes the key issue in Dobbs of why Dobbs overruled the Roe decision. But at least the Casey plurality was so worried about legitimacy that they could not do it. And they also talk about reliance interests, the Casey plurality. What is that reliance interest? What is that? Reliance interest.
Reliance interest.
That's why I said pina colada. That's actually funny. Do you like the pina colada? No. And what's reliance interest? Brenda? Who's relying on Casey and Roe?
Future court.
No, not court. Who relies on Roe? Women, and not just pregnant women who might become pregnant, right? The court makes a very big deal about reliance interest. That is, Justice Kennedy says that people structure their entire lives on the availability of an abortion as possible. In other words, they engage in sexual relations. Birth control does fail sometimes, it happens. And they know as a backstop of abortions there, something happens. And they make this point, which is somewhat controversial, but that women's place in the economy is premised on the ability to have abortions. That they may not be able to climb the corporate ladder and build careers if this is taken away from them. In fact, in the Dobbs decision, there was an amicus brief submitted by, I forget the number, might have been hundreds of lawyers who had abortions saying, if we did not have an abortion, we would not become attorneys. If we had to raise his children and have families in our life, we couldn't have gone to law school. There was a brief that was filed and a significant number of women signed it. So they're worried not just about the legitimacy of the courts, but how women themselves have come to rely on the precedent of Dobbs. The precedent of Roe. Okay. Everyone with me so far? Okay. The court acknowledges, though, that precedents have been overruled. Right? Plessy was overruled more or less by Brown. Legal tender cases, remember those? West Coast Hotel. So there have been changes in precedents, but they say there's a serious cost in doing so, and that Roe does not justify the removal. All right, so we're gonna get that. We'll come back to stare decisis and Dobbs. I don't want to spend too much time on it because everything I just said is no longer law anymore, right? That Dobbs didn't merely overrule Roe and Casey about substantive due process. Dobbs rejected the Casey approach to stare decisis. That's the fun question: is precedent by precedent subject to stare decisis? In other words, should we give Casey stare decisis when it's talking about precedent? And the court says basically no. All right. Yes, ma'am.
Is this case not dicta anyway?
Well, it's a good question. Only 3 people joined it, right? It's not a majority. So Casey by itself is only the 3 members. There's no controlling opinion there. But in 2016, the court decided a case in Texas called Holden's Health versus Hellerstedt, where the court reaffirmed Casey. So between 1990, was it 1 or 2, and 2016, the answer is unclear. But between 2016 and 2022, yes, Casey was law, at least that much. But for practical purposes, everyone treated joint opinion as law. This is like how like Bakke, right? When there's a narrow opinion, you make the narrow opinion the holding. But formally, there's no opinion of the court. Why? Because Justice Stevens and Blackmun would reaffirm Roe in its entirety. They don't want to do this undue burden stuff. They did not want to do it. Right. Then we get to Justice Kennedy, who I've not talked about much this semester, but I'll talk about a lot more in the next class, or actually almost done. He used to spend about a month on Justice Kennedy, and now he's down to a class and a half. Times change. Justice Kennedy was basically the center of the Constitution for about 30 years. Whatever he said went. He was the most important man in America, more than the president or anyone else. He decided who lived, who died, who has an abortion, who doesn't, whether we're at war or not. He would make all these decisions himself. It's kind of just startling that one man would have so much power. But again, not even Reagan's first, second choice. He was the 3rd choice when no one else could get it. Okay. So Justice Kennedy had a way of writing that is sort of unusual, and maybe you sort of noticed it. he speaks about morality and spirituality and the mysteries of human life. I'll just read you a few sections. Our obligation is to find the liberty of all, not to mandate our own moral code. These matters involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. This is my favorite one. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. It's like a very, very poor freshman philosophy paper, right? It's just dribble. There's really no other. He's just vomiting on a page. You can like abortion rights and you can like gay rights and all this stuff. That's one, but this is not law. It's not even trying to. I have such a joy that I don't have to teach his opinions anymore. It's actually it's a point of pride for me. But with Justice Kennedy, you had to join it, right? You think Ruth Ginsburg written a better opinion of this? Yeah, she could have. You think Stephen Breyer could have? Yeah, he could have. But they needed Kennedy's votes to liberate everything. Justice Kennedy wrote all these opinions in Casey, in Romer, and in Lawrence, and in Obergefell. And the other members just put a clothespin on their nose, just swallow their pride. But what's significant here is the shift. Roe focused on a right of privacy, right? Do you see talk about privacy here? No. It talks about liberty, and the other magic word is dignity. Dignity. What's dignity? Andrew? I'm sorry. What's dignity?
Dignity would be pride, the ability to make your own decisions and not be demeaned while making them.
What does demeaned mean?
Put on a lower pedestal or just simply made fun of.
So where in the Constitution is a protection for dignity? Why is dignity protected by the 14th Amendment?
It's not.
But why? Humor me. Why would the Constitution protect? I know it's not. The entire thing's not the Constitution. But why would the Constitution protect dignity? Just assume Kennedy's right.
Because for the 14th Amendment, it'd be because dignity is associated with liberty and difference.
Okay, Trent, was your hand up a minute ago? Okay, yeah, Oscar. What about the penumbras? I don't know. Okay, so you tell me. Okay, so I think you're also hitting on it. Justice Kennedy's jurisprudence, and this you see this in several cases today, was saying that people should not be made to feel less than who they are. In other words, the government can't make you feel less as a person. So in Casey, what was the problem? You were mandating that a woman has to get her husband's permission to have an abortion, right? That you're putting her as if, a parent has supervision over a child, right? You must get your dad's permission before you go on a field trip, right? It's demeaning, to use your word, right? It's demeaning the pregnant woman to have to get the husband's permission to have an abortion. What about in Lawrence? We'll say that in a few minutes. In Lawrence, it was demeaning to a gay couple that they can't have sex and they can't have their relations the same way a straight couple could. What about in Obergefell? One of the defining issues was children. That children of gay couples would be demeaned, that they're not treated in the same level as the children of straight couples. Right? In other words, the law itself cannot demean people. It cannot treat them as less. Even if there's no actually equal protection violation, in the sense that you're treating, people differently based on their race or their gender, you can't make persons just feel lesser. Everyone see the Kennedy argument, right? Again, yeah, right. It's not the Constitution. That's actually not even that's not even the issue of the day. But when Justice Kennedy speaks at the heart of liberty, is right to define one's own existence, of meaning, of the universe, of the mystery of human life. It's we're all in this kind of like choose your adventure, right? You can figure out what makes you happy as a person, what gives you fulfillment, what gives you your pride, your dignity, and the government cannot take that away from you. So we shift from a right of privacy that the government can't bother you, they can't intrude in your private affairs, to a right of dignity and autonomy that you can make decisions about yourself. That includes abortion, that includes the right of sexual relations, and even later includes the right of marriage. Yes.
Can't treat people as less than another person.
He would use the word demean, which I'm actually glad that he used the word demean a few minutes ago. That you can't basically question, or you can't prohibit the choices people make that are essential to their dignity and essential to their personhood, who they are. Right? Now that's it's a philosophical statement, for sure. How do you then apply this to abortion, right? The court comes up with this new test. They call the undue burden standard. The undue burden standard. And to be clear, they didn't make it up here. It was kind of hinted at in some other case in the 80s, but they made this more or less the holding of the court. And what the court does is like this. After the point of viability, right, the 6-month mark, more or less, the state has very broad powers to limit abortion. Okay. That part of Roe is maintained. Okay. You can ban abortion after viability, subject still to the health of the mother. Okay. What up before the point of viability? What the court says is you cannot impose an undue burden on abortion. Again, prior to the point of viability, again, it's not 6 months. They don't have the trimester, that's out. It's the point of viability. And that means viability will float around as technology improves. Whatever viability is, prior to the point of viability, a state can restrict abortion, but they cannot impose what they call an undue burden. Undue burden on abortion. What is an undue burden? The court defines it as a substantial obstacle. A substantial obstacle to obtain an abortion. So they can put, I guess, minor obstacles, but not substantial obstacles. What does that mean? Having to sit through a sonogram when you're pregnant before you get an abortion. The court says, well, that's minor. But being forced to not obtain permission, to seek notification of your husband, if you're married, that's too much of an obstacle. It's almost just like this sliding scale. The court says, well, Goldilocks, that bowl of porridge is too hot, that one's too cold, okay, that one's just right. The courts then have to decide how large of an obstacle there is before obtaining abortion, and is all before the point of viability. That is what Casey does. Casey gets rid of the trimester framework. They get rid of strict scrutiny, and they get rid of this fundamental right. And they say, prior to the point of viability, we use undue burden standard, and after viability, you can do what you want to say with the health and safety, health of the mother. Everyone get the shift. They made several significant shifts. I think this chart summarizes it quite well. Oscar's in hand?
This whole substantial obstacle thing, isn't that what Scalia was harping on? Like, how do you decide, like, who's the ultimate decider of this substantial obstacle?
Right. I mean, so the benefit of Roe is it's clear, right? It was a bright line rule. Judges did not have to do much balancing. Whatever you want to say about Roe, it was clear, right? This is like a tort suit. You love 1, 2, 3, right? Everyone knew what the rule is. Casey replaced a clear standard with a very flexible standard, where it'd be up to judges, and in particular lower federal court judges, to decide whether a burden was undue.
Would you say that this is a larger expansion from Roe, or like the court? It feels like they got rid of their ability to make a statute, but then gave them the right to decide what a moral consequence.
Well, I think you're hitting on a bigger issue. It's true that Roe was an overreach, right? Roe was an act of legislation, as the court said, or as the Senate said. Casey said, we're not going to be like that, but basically we'll give judges more flexibility. right? Give judges more discretion to decide which laws are valid or not. So in other words, it was like whack-a-mole from the carnival, right? You pass a law and you have judges became like whack-a-mole, like, oh, I'm gonna hit this one, but not this one, right? So the legislature didn't know what the law was even gonna be. One of the issues they say with stare decisis, the law to be clear, right? Liberty has no refuge in jurisprudence of doubt. You know what created some doubt? Casey. Casey created massive doubt, where legislature spent 30 years trying to figure out what they can even do. And the judges of different stripes say, oh, you can't do this, you can do this, or you can do this. You know, for example, Texas passed a law that says, if a woman has an abortion, he must bury the fetal remains. Right? In other words, it was a burden not before the abortion, but after the abortion. And courts know it's unconstitutional. Right? Texas had laws requiring, this is Holman's Healthy Hellerstedt, requiring facilities that provide abortions to have certain health standards. And basically you have to perform surgery there if something bad happens. For dispensing medicine, you have to have admitting privileges at a hospital, right? The states experiment said, no, you can't do that. That's much of a burden. You can't do that. So it created this 30-year span where the justices decided what was and what not. They also had the partial birth abortion ban cases. I don't teach this anymore. They're in your book, where basically you'd have an abortion ban even in the 9th month. Or that was after viability, so that's a different story. But the pre-viability restrictions, it was like a whack-a-mole for decades. Yes.
So why would they put that whole part about stare decisis when they essentially gutted like the main?
I mean, that's what Rehnquist and Scalia said, right? Rehnquist and Scalia said, how do you give this sort of this beautiful tribute to stare decisis when you're rewriting the very precedent you're purporting to reaffirm? I don't have an answer for you. Right. I mean, I think what the court basically says is there was the holding of Roe and the central holding of Roe. And we're only affirming the central holding of Roe. Meanwhile, Justice Blackmun, who wrote Roe, didn't join that. It's like, this is not Roe. This is not what I wrote. So Casey was this kind of this sort of glitch of constitutional law where there was a compromise made. I mean, it's not similar to Obamacare, right? The Chief Justice, in a deference to legislature, rewrote the statute. Right? The Chief Justice said, we need to defer to Congress, and to that, I'm going to take my pencil and scratch everything out of the statute, write a new statute. It's sort of anything. Whenever the court has these sort of compromises, they always go the same way. Right? Compromises never go towards the law. They always go away from the law. I'm tired of these compromises. They're hard to teach. And the irony, of course, is that in the Obamacare decision, Justice Kennedy voted to strike down Obamacare. And it was John Roberts who had the compromise and switched positions. So, and not surprisingly that John Roberts did not join the majority in Dobbs. Yes, sir.
I wrote down in my notes that I thought that it was like the Obama.
There are analogies. Yeah, there's similarities. It's a good observation. Yes, Bobby.
So how does this fit within footnote 4?
Oh, okay. Footnote 4. Abortion doesn't fit to footnote 4 at all, right? It's an unenumerated right. If you're subject to a rational basis standard, that's the answer. Footnote 4, Justice Scalia called them. Footnote 4, by the way, was not a majority. It was a 4-member plurality. Scalia called people like footnote 4 the dictamizers. I love it. It's a dicta. They're the dictamizers. I wouldn't sweat to footnote 4 too much. You're not wrong, but just it doesn't really matter anymore. Yeah, Oscar.
I think that's no longer in it, but in Obergefell, Roberts like quite literally went against what he like said not to do this and then did that in Obama.
And then he didn't dissent. Then he didn't join the majority in Dobbs. Yeah, Roberts is a study in contrast. His Obergefell dissent is like a different human being than the Obamacare ruling. It's like a different person. It's like Invasion of the Body Snatchers. Like, I don't know. And by the way, Lochner. They keep talking about Lochner, right? Lochner, nonstop in this case. They stress Lochner was overturned by West Coast Hotel. Kind of. And then meanwhile, in the dissent, Rank was like, you're doing Lochner. You're engaging in Lochnerism. They cannot get away from the bakery. It's amazing. Cannot get away from the bakery. All right. So again, I used to teach this case as this is the law, and now I can't say it anymore. But you at least get what the law was in the 90s after Casey. All right. So let's move forward, and the chronology here is a bit tricky. So Casey was at 91, 92, 92. So Casey was 92, and we fast forward 5 years to Washington against Glucksberg. Does anyone remember the name Jack Kevorkian? Does that name ring a bell to anyone in this room? Dr. Death? So in the 90s, this was a huge issue that sort of faded, but it's still there. And the issue is physician-assisted suicide. Physician-assisted suicide. And the name's exactly what it sounds like. A doctor assists a person to end their life. Now, there's a difference between, pulling the plug and withholding life-sustaining treatment versus giving someone a medicine or a drug that will kill them, right? That will cease their life functions, right? There's a difference. In every state, if people say, and there's no actually, you're actually pulling a plug, right? There's not actually pulling a plug from a wall, right? But in every state, if a person says, please stop providing me with treatment, they will. So, for example, my grandfather, for example, he became quite old and he had senility. And his wishes were, if I can no longer take care of myself, do not give me a feeding tube, right? Do not give me intravenous fluids. Just let me go. And he did. He had senility. He lost his way, and he died of thirst, dehydration. A lot of people go that way. No, it's sad, but the point is, failing to provide treatment is different than giving someone a cocktail that terminates their heartbeat. Okay. A movement started in Europe, mostly everything starts in Europe, it seems, where doctors would approve treating people with chronic illness, with terminal illness, to basically end their lives. There are cocktails you can give. I think you drink like a subpoena colada, right? They're drug cocktails you can inject that basically will stop a person from breathing, that'll stop a person's heart from beating. It's not dissimilar to what a lethal injection is, right? In fact, one of the ironies is in American prisons, no one sells them the drugs to have lethal injections, but in Europe, they can get them at a corner drugstore. I'm exaggerating slightly, but not much. There's a huge ethical issue here. Why? Suicide has long been illegal. Now, of course, if you actually commit suicide, you can't be prosecuted. But there were consequences for a person who commits suicide. Their family may not be able to inherit their property. Like, how do you prevent a person from killing themselves? You punish their families. And historically, you would basically say the property cannot be inherited. Even the Jewish faith, if you commit suicide, you have to be buried in a Jewish cemetery. These are long-standing prohibitions. Conversely, if you assist a person with committing suicide, it's called murder, so you'd be charged with murder, right? If you shoot someone and it's, oh, I want to kill myself, okay, you shoot them, okay, that's murder. If you give someone the drugs they inject themselves with to end their life, okay, that's called accomplice to murder, right? There are different ways you can charge us in any sort of criminal statute. So in the early 90s, there started to be different states that were considering this. I think Oregon was one of them that actually approved assisted suicide, the physician, right? But Washington considered it and rejected it. I think they have it now. And California considered it and rejected it. They have it now. The number of people actually do this in California, in Canada, is actually staggeringly high. It's not even just old people; it's even young people with depression. It's used quite broadly. It's a very, very difficult issue. But in Washington, the doctors asserted, actually, the plaintiffs were originally the doctors and patients who wanted to commit suicide, but then they died of whatever was afflicting them, so they never made it to the case. But at least Glucksberg was a doctor, and he asserted a substantive due process right to terminate a life. A substantive due process right to assisted suicide. So, Michael, let me ask you a question, please. If you were the lawyer for the Dr. Glucksberg, how would you define the exact right that you're seeking?
Oh, I would say that it's fundamental.
Why is it fundamental?
The right to kill yourself.
If you say the right to kill yourself, do you win in court?
No.
No. So I'm asking, how would you describe this right in court if you actually want to win your case? Which is a good thing for lawyers.
Oh, yeah, I would say that it's, the right to define your, life.
Oh,
Yeah.
intimate decisions, right? Intimate choices. Yeah,
It's a right to provide care,
you're doing the opposite of that, though.
well, as a job, as the job.
You Hippocratic oath, you actually helping someone in that case?
The whole concept, like, what they're saying is they're like easing like stuff.
Well, there's no prohibition against giving morphine or a sedative, but these are things that stop your heart from beating. In other words, I mean, I'm not a doctor, maybe people are doctors here, the Hippocratic oath, right, where you do no harm. The argument has to be that this is actually eliminating harm in the long run, but in the short term, you are quite literally harming someone. But I want to go back to Michael's point a minute ago. I think he said the issue well. If you come into court and you say, this is a right to kill yourself, or, pardon my French, a right to have sex, right? Or a right to terminate a pregnancy. That doesn't sound very good. But if you use Justice Kennedy's sort of approach, this is a right to make intimate choices about your reproductive rights, about your place in society. It's right to decide how you live your life with dignity. It's a right how to have intimate love with another person. So much turns on how you define the right. Think back to Bowers against Hardwick last week. How did the court define the right in Bowers? It said, well, there's no right to have homosexual sex, period, end of story. There's no substantive due process right. So much turns on the careful definition of the right, and this is what Glucksberg teaches. Stephen?
So, I'm really confused on like why they're not using when they're looking at what the, like, finding the right, deeply rooted in nation's history. Waiver of human rights, I guess.
I'm gonna get there in a minute. I promise. Okay. So Glucksberg is an opinion by Chief Justice Rehnquist, decided 5 years after Casey. In almost every regard, Casey and Glucksberg are at odds, right? Casey is forward-looking, that we look to the present day and the future to decide what our rights are, right? We have this, what Justice Kennedy would call an emerging awareness, that we know things that those who lived long ago didn't know, that we have now wisdom, that we have insights the framers simply didn't have, that we know better because we're in an enlightened society, right? That's the thrust of Casey and Lawrence. But then you have Bowers and you have Glucksberg. Those are not forward-looking, not looking at Europe. They are backwards-looking, looking back to the 1860s. They're saying we only protect those rights that are deeply rooted in our nation's history and tradition, right? History and tradition is the magic words of the day. History and tradition. We only protect those rights that are deeply rooted in history and tradition. And then there's a second step, that are carefully described. You have to carefully describe the right. You can't just say you have the right to love, the right to intimacy, the right to dignity. No. You have to carefully describe the right at issue. In this case, the right to terminate a person's life. The right to end a person's life. Even if they consent, right? If I say, hey, can you shoot me? I give you consent. Can you consent to that? No. Right? Maybe when a boxing, you consent to a boxing match, I'd punch the heck out of someone, but you can't consent to, yeah, you can murder me. Go ahead, please. I give you permission. Pay my family some money. You can murder me for fun. Like the Purge, right? You can't do that. The most dangerous game, if you read the story. Yeah.
What about like duels and like how people use that duel?
Well, both of them were criminals. Dueling was a crime. You know that to be a lawyer in Kentucky, you actually have to take an oath saying you swear not to duel. It's on the oath. I swear it's in there. This is why if you're watching Hamilton musical, they always have their seconds, right? And the seconds have to turn their back, so they say, "Oh, I didn't see what happened." Plausible deniability. Dueling was a crime, but everything was legal in New Jersey, as Lin-Manuel Miranda tells us. 1, 2, good.
So I was gonna ask, in terms of the careful description, are we supposed to define it narrowly? Because of course, we would give them.
This is $1 million question. If you read Rehnquist, you go narrowly, but if you read Kennedy in the Lawrence case, he basically ignores it. So this is actually kind of a fun part of teaching this case. I've actually never done Glucksberg before. In fact, I would argue to Randy, let's just take this case out of the book. It doesn't matter anymore, right? Lawrence repudiated Glucksberg. Obergefell repudiated it. Randy's like, well, it's still there. And he was right. I was wrong on this one. Glucksberg is the law today. When you read Dobbs for class on Wednesday, and it's long, so please get going in the reading. If you read Dobbs for reading on Wednesday, it applies it. And they say the right is not just do women have the choice to make decisions about their intimate, lives. It's can you terminate a pregnancy at 15 weeks? That's the question. Glucksberg says, right, step one, is the right deeply rooted in history and tradition? Right? But step two, really, it's the first step to come out of order. You must have a careful description of the right. Careful. This is what Rehnquist was doing. He was trying to limit Casey. Glucksberg undermines Casey. But Justice Kennedy was never one for consistency. He didn't really care. He was like, well, I like abortion, but not assisted suicide, so that's fine with me. There's really no way to reconcile. He thought, okay, we don't want people killing themselves, but they can have an abortion. Because he could, when he says we don't have our morality code, it's the exact opposite. That's precisely what he was doing. And he was having his own code of what he thought was acceptable. Yes, Oscar.
Why here do they take the focus on history and tradition, but then in Lawrence they don't?
You're asking a very good question. The reason why is that Justice Kennedy had the majority in Lawrence, and Justice Kennedy did not have the opinion in Glucksberg. He didn't really agree with Glucksberg, but he didn't, he kind of said whatever. When we get to Lawrence, they say, well, and Obergefell, to be sure, we don't follow Glucksberg anymore. This is why Roberts says in his dissent in Obergefell, they basically have to overrule Glucksberg to get to this ruling. Roberts was right. Again, his Lawrence dissent's like a different human being. His Obergefell dissent, he's like, oh wow, I'm a judge again, right? When Roberts is in dissent, he means it. When he's a majority, he doesn't mean it. He's just trying to balance it. When he writes a dissent, he actually means what he's writing. It's actually very powerful. He's only written ever one solo dissent his entire career. It was a case involving damages. It wasn't even an important case. We had one solo dissent ever. It was a boom a couple of years ago.
For careful description, is that what the lawyer is asserting or past precedent?
I think the government has to carefully describe the right. Right? I think what they're saying is we defer to the government about what they're trying to do. They're trying to ban people from helping others commit suicide. That's the actual right being asserted. It's not, we're trying to ban people controlling the dignity of their lives. No, they're saying you can't help someone commit suicide. And in terms of history and tradition, every state in the Union banned assisted suicide. They all did it. And they've done it for hundreds of years. Going back to the 1300s, they banned assisted suicide. There's such a deeply rooted tradition here. This is an easy case. But now any reasonable person might say, well, what about abortion? Right? Didn't Roe strike down the laws in 46 states or something? That every state in the union had these laws? If you actually apply the Glucksberg framework to Casey cannot stand. I nailed it. Ooh, better.
Here, why is it that they give deference to the government here, but then in
Casey and Lawrence.
they just
This is a ping pong match, right? And this is why it was hard to teach Glucksberg. I didn't teach it in past years, so it's hard. This was Justice Kennedy. As often said, what will Justice Kennedy do? Depends what we had for breakfast that day, right? He was such a fickle, mercurial person. He would just rule in inconsistent ways consistently. He never explained himself. And there was this 30-year cat mouse game between Scalia and Kennedy, where Scalia's like, don't believe him. He says it's not about gay marriage, it's about gay marriage. And then it's about gay marriage, right? No, I'm not saying it's aliens. It was aliens, right? He would just sort of just not say what he was doing. I mean, just as a judge, again, I'm not criticizing because his outcomes, his reasoning was never tight, right? The reasoning didn't matter. It's just we have an emerging awareness. There's dignity. There's some articles being written. There's people talking about it. That's good enough. It was teaching ConLaw was very hard when Kennedy was in charge. People would say, well, when you put a brief to the Supreme Court, put Kennedy's face in the cover. It's like, hey, hi, Justice Kennedy. Here, rule for me. Here's what I have to do. And it wouldn't matter what else anyone said. Oh, yeah. Oh, Scalia was taking shots at Kennedy for decades. And they were neighbors. And this guy they burned as well in Casey, right? don't get me wrong, Kenny was a very nice man. He was a very kind man. He was very lovely in person, but his jurisprudence was basically fluid, and it didn't. He never responded to dissents. It's something that sort of what was annoyed me. Scalia would have this barn burning dissent, and Kenny would be like, yeah, whatever. I got the votes. I got 5.
So, like, Scalia says, like, they were essentially, like, voted in for, like, political reasons, but he was voted along with those guys, so he exempts himself from that exact line of thought.
Scalia?
Yeah.
We mean voted just like those guys.
I don't know what we should have said it, wasn't he was saying, like, these justices were essentially put in here to decide the right of abortion, and it's like they're deciding political matters instead of constitutional matters along those lines.
It's like, I don't think Scalia objects to judges being appointed, but just what are you doing with an appointment? I think that would you to respond like that. But let me move on. So Glucksberg says, what are these guideposts? In other words, we only protect those rights that are deeply rooted. Let me ask you a question. I think Jake, you're next. Jake, if we only protect rights that are deeply rooted, can any sort of new or modern rights ever be protected by the Constitution? I'm talking about the Glucksberg. If we only protect those rights that are deeply rooted, or any sort of new rights ever be protected? I'm asking about Glucksberg. If Glucksberg's right or any new rights ever been protected? Why?
Because they only look that.
Good. Yeah. If Glucksberg is right, there are no modern rights. Not abortion, not sodomy, not gay marriage, nothing. Rights are kind of frozen in amber, to use the chief's language from another case. So if rights are sort of frozen in amber, that they're sort of trapped, what are these rights? Ted, what are the rights then that under Glucksberg would be deeply rooted in history and tradition? Where do we know what these rights are from? Which case would tell us that? Good review question. Anyone? What case tells us what these rights are deeply rooted are? Meyer. Good. What does Meyer say?
There's like 9 of them. The
Yeah.
family.
Family, yeah. Family, raising children, speech, religion, conscience. We go all the way back to the Lochner era, don't we? That only those rights are deeply rooted and protected. And by the way, when they said marriage, they didn't mean gay marriage, just to be very clear. They meant traditional marriage. So what the Glucksberg test is doing is basically freezing in time substantive due process. But if that's right, then sure as heck the penumbras are wrong. If that's right, then sure as heck Roe is wrong, right? The careful description of a right, go look at the penumbras. That's not careful. So Glucksberg is kind of like this outlier in this sea of substantive due process. Glucksberg's like, please stop, don't do this. And it lasts like for 5 or 6 years until Lawrence. Yet the irony is that Justice Kennedy, because he didn't care about precedent, didn't actually overrule Glucksberg, and it came back in Dobbs. Came back in Dobbs. I didn't think it would ever happen, but it did. So this is why we kept it in the book. See your hand? Please.
So like, I mean, it seems like the opinion's more answering like the question about like the patient's right to that like kind of procedure less than it is about the doctor's right to perform it. Is that?
Well, it's a funny thing because it's a right you need someone else's help to do. So for example, abortion. Generally, well, you can't have an abortion by yourself. Now with medicine, I guess you can, but it's supposed to be dispensed. But almost every abortion requires a physician and a woman, right? You have to have both. With assisted suicide, by definition, you need someone's help. I mean, I guess you can put a gun to your head or jump off a building or something, right? But you need someone else's help. So the court has basically said that the right that exists extends not just to the person who's receiving the treatment, but the right to give it. It's one of these weird outliers with abortion law and substantive due process where other people can share your right with you. The right to get married that involves a couple, right? Don't say throuple. They don't talk about polygamy in that case, but at least 2 people have to exercise the right. The throuple is a couple of 3, or was it polycule? Polycule with multiple people in a relationship. Polycule, like a molecule, but polyamory. I don't know those things. I read about them. Yes.
So, Justice Rehnquist would apply a rational basis standard.
Yes,
to
ma'am.
every-
Basically everything. Every modern right goes through rational basis. It says, there's a very good reason why we ban attempted suicide, right? People might be exploited, maybe people don't provide full consent, right? There's a lot of risk for abuse here. This clearly tests the rational basis standard.
Which would be conscious or conceivable basis.
Correct, yeah. And he even goes more, he says there's actually a legitimate basis and an important basis. He basically says, this is probably clear from intermediate scrutiny, right? There's a very good reason why we want to ban assisted suicide. But the purpose of the Glucksberg test is to narrow the discretion of the judges. It's to avoid what case? Lochner, right? It's to avoid Lochner's that we don't appeal to our own sense of justice when we're deciding what rights are.
This one with substantive due process still,
If you asked that question 3 years ago, I'd say no. Dobbs applies Glucksberg. Again, this is a case that kind of didn't make sense until Dobbs. And of course, it was in 1997. Only Justice Thomas is left in the court from that period, right? So, but it kind of just sat there, just lingering around. It's when you think of precedent, when you don't overrule precedent, it just sort of stays and that just floats. And you never know what's going to be useful. You know, like even like Wickard, right? You know, economic activity. Oh, it's about economic activity, right? Precedents have a way of being reimagined years later, coming back to in ways we're not anticipated. So we have to know all these cases, unfortunately. Like to go from Dobbs to Casey to Meyer, like Michael did a moment ago, like that, these are the sort of inferential jumps you have to make in this class. Cases never go away. They're always there. Is there more?
so this is essentially indicating Harlem to Brazil. But are they really harping on anything that that's in the Constitution?
I don't even know what that means. I mean, no one knows what that means. And I think I actually said it was Cardozo. It was actually Brandeis. I was wrong on that one. I made a mistake. So they have a Jewish justice. I can't remember them. Sorry. Poo-poo. Right. I don't know what that means to this day. What implicit. The part that matters is this right deeply rooted. What that means is modern rights will not be protected. So I didn't assign this case, but I'll just mention it. McDonald v. Chicago. Right. The right to bear arms. Is the right to bear arms deeply rooted? The court says yes. So it's a fundamental right. So actually, the next edition of the book, McDonald, becomes a substantive due process case because that's how the court treats it. So that was actually Randy's idea, which was my idea, but he executed it well. All right. Any other questions on Glucksberg? Yes, ma'am.
Doesn't equate to a fundamental right. It's just if it's deeply rooted.
If it's deeply rooted, that means it's fundamental.
Okay.
If there is in fact a right that's deeply rooted, that's a fundamental right. If you read Meyer, case Michael mentioned a moment ago, it speaks of fundamental rights. So this is not like made up of folk law. Is this deeply rooted in tradition history? Now, I'll criticize it. Who gets to decide what rights are deeply rooted? There's still a judge. There's still a judgment there. There's still a judge element to that. You know, I'd argue the right of contract's deeply rooted. It goes back to Lochner. Goes back to Slaughterhouse. So if you want to talk about a deeply rooted right, we're back with the Bakers. Now, what's curious is that Chief Justice Rehnquist responds to Casey as well. Casey described rights more generally, but we're doing it differently here. They did not overrule Casey, but they also didn't reconcile with Casey. They're sort of at odds with each other.
And then when it's going against a deeply rooted right, then it's a big, just a rational basis.
No. If the right's deeply rooted, it's fundamental.
Right.
And then use strict scrutiny.
But I'm saying, so like for this, assisted suicide.
Was not deeply rooted.
Right, so then it's rational basis.
Correct, ma'am. Yes, ma'am. Yes, Sean.
If we're gonna start with the evaluation, we start with Meyer in terms of evaluating whether or not it's deeply rooted or should we go further.
So
back?
one of the ironies of this framework is they list them out of order. The first step really is carefully describe the right and then see if it's deeply rooted. I don't know why Rehnquist reversed it. It's sort of backwards. The first thing is this right carefully, what's the right that's carefully described? Second, is it deeply rooted in history and tradition? And by the way, tradition comes after ratification. So history is what happened before ratification. Tradition is what comes after ratification. So it's looking even after the Constitution was amended, we look at what the people did as proof of what the rights are. It's actually a very controversial element. Why are we looking to after ratification? What did the text mean was ratified? No, we're going even beyond that.
So we should start with ratification and work our way forward.
For purposes of my exam, we don't have time to any of this stuff, but in theory, in constitutional law, start out the history before ratification, then go after.
Okay.
Text, history, and tradition. What does the text mean? Carefully describe it. Then the history before ratification, then tradition afterwards. Justice Kavanaugh loves tradition, loves talking about tradition, right? Everything's about tradition with this guy. Justice Barrett does not like tradition, so they have a little beef right there. I did not assign the Rahimi case or the Bruin case, but this comes up a lot in recent Second Amendment cases. And also Vidal v. Elster. Yeah.
When they're looking at the history and tradition, are they looking at like an Anglo-American jurisprudence?
Well, what does Rehnquist look to? He looks to English laws in the 1300s, right? Laws in the colonies, right? Laws in the states after independence, laws in the territories in the 1800s, right? In every jurisdiction in Anglo-American history, suicide was a crime, and attempted suicide was a crime. It's pretty consistent. Much the same piece about abortion, right? Almost everything that's said here about suicide, I think would apply with similar weight to abortion.
Would it be fair to say that, the list of things that they made in the Declaration of Independence with King of England, like, impeded on their rights would be fundamental?
I'd say so. There's a fundamental rights. That impel or separation from the king? Yeah, I'd say so. By the way, 250th anniversary of the Declaration is next summer. You guys have a good barbecue planned? I think we're going to school. I don't know if we can something out.
Didn't you say you made sure your daughter was born on 4th of July?
Kind of. Some things you can time. No, it was a natural delivery with undue, but she'll kill me. They wanted to do some June 3rd, like absolutely not. And we did know the doctor had a plans for 4th of July weekend. That's what they wanted to induce. Although doctors want to induce, it's often their schedule, not yours. Trust me, this one. The doctor had plans, and doctors get paid for the delivery. It's actually one of the things they don't know. They don't really get paid for all the checkups and all the visits. They get paid for the delivery. That's the big payday. They want to be the one. So actually, we had another doctor deliver on the 4th. It was very good. Very nice. But June 30th, it was. Nope, not inducing that day. No, so close. Oh God, that would have been terrible. What? June 30th? July 1st? No, we're not gonna have July 1st. Bobby, save me, please.
So I just wanted to make sure, can you use, like narrowly tailored and stuff like that for due process strict scrutiny? Like that kind of language? Or do you have to, word it just?
So before Dobbs, if you ask me that question, I would say there really are, okay. These are, okay, let me say it like this. If in fact there's a fundamental right, there's not really any balancing. The government can't do it, right? Like under Roe, if there's a fundamental right, you can't ban it, period, full stop. So you don't talk about its compelling interest. You don't have to talk about, narrow tailoring. Casey, though, said we're going to post something called the undue burden standard. The undue burden standard is somewhere below strict scrutiny, but it asks, is there a substantial obstacle, right? So that's a form of scrutiny. Now with the Dobbs test, it's rational basis. I don't know, and I mean this sincerely, I don't even know today what are the fundamental rights that are not deeply rooted. I don't know what they are. I think it's a set of 0. So there's really not much substantive due process left. One possible area is the right of parents. So I go back to Scrimeti for the 100th time, right? Do parents have the right to direct the medical treatment of their children to obtain these hormones and other puberty blockers and stuff, right? Is that strict scrutiny? There's a case argued last week called Mahmoud, which involved whether parents can opt their kids out of reading certain LGBT books in public schools. That's right, parental rights. Is there balancing? Is that narrowly tailored? It's also maybe a free speech issue. So the short answer, Bobby, is I don't have an answer for you. I've given you something that probably complicates it even further, but there's not a clear answer to what you're asking. Sorry. I apologize. You're asking very good questions, but I just don't have an answer for you. I think I'll have an answer for you maybe in July of this year. So if you want to, maybe on Rick's birthday, we'll go celebrate and we'll go talk about independence in Canada and the Supreme Court's term. Well, the downside was I was expecting with the July 4th baby that the Supreme Court would be out of session, and it was good timing. Unfortunately, that was the year of COVID, and they went till mid-July, so I was reading opinions in the hospital, and that's how it's true. The Supreme Court ruined my summer. June 2020 was the worst year of the Supreme Court ever. It was just dreadful. Every opinion was bad. That was like John Roberts' lowest moment as a judge. It was really bad. I called it Blue June. It was just very sad. All right. We got Bostock and McGirt. Oh my God, one after the other. All right, what else? Trump tax cases were that year. Just one after the other. Bobby, please stay with me.
But when you're using rational basis, then you probably use the same language from.
Well, rational basis is easy. Yeah. Is there a legitimate interest? Yeah. Is there some sort of narrow tailoring? Yeah. I mean, look at what Rehnquist does in the what do you call it in the Glucksberg case. That is rational basis scrutiny, and it's hard. And he applies things very, very carefully, more carefully than probably deserved. Like, he didn't have to do that. He said, "Be optical, good enough for me," but he actually went beyond that.
This just applying the clause of the idea for the executives onto the judicial branch.
I think I know what you mean, but I'm not sure.
Like the gloss of an executive can do it as long as they've been doing it. And the
Such
judiciary is
a good question. So tradition, right? Justice Scalia referred. Did you adverse possession yet? Justice Scalia referred to tradition as adverse he referred to gloss as adverse possession. As if you keep doing something for a long enough time, you acquire the power to do it. Right? You're squatting. And I agree with Scalia. Tradition works in the same way in substantive due process, where if the government keeps doing something for a long time, they basically get the power to do it. The problem for the court, though, was actually in the Bruin case. They were reviewing a New York law that banned carrying firearms. The law was in effect for 130 years. And the court said, no, that's not long enough. So I don't know what tradition adds to it. I'm actually not a fan of tradition. I'm actually with Justice Barrett here, who I don't usually agree with. But Justice Kavanaugh loves tradition, and it's very similar to the gloss. Another word I'll give it to you is called liquidation. Have you ever liquidation? Liquidation is the idea that when you do something over and over again, you basically settle or liquidate the meaning of the Constitution. James Madison wrote about this and a few other people. I'm not a big liquidation fan. I think it's Federalist 37. You can check on that one. But Justice Kavanaugh loves liquidation. So yeah, make the argument. Look, you make the argument the justices want to hear, right? It's not what would Josh want, right? That doesn't really matter. It's what would the justices want, and you have to advocate for them. Same with any appellate judge. If you're arguing for the Fifth Circuit, you find out who's on your panel. You better damn well know what they think, right? You can't do it for the brief. The brief you write in advance, but the oral argument, you can peg it for who's on your panel, and you know what questions they're going to ask. You have to know your bench. If you're a district court judge, you have to know your judge. So I don't care what court you're in, know your judge, because that's your audience. Yeah.
Doesn't Glucksberg,
Glucksberg.
we're looking at substantive due process, we will only apply, that's not personal, Meyer and Pierce for the reasonably related.
Again, one of the weird things is if a right, in fact, is deeply rooted, the government's not going to ban it. Right? In other words, if some right is actually viewed so fundamentally as important that there's no law regarding it, it's only the newfangled rights that have bans on them, like abortion or relations or whatever.
I guess I'm confusing myself because I thought the conceivable fixes that because constitutionality.
Reasonable, it's the same thing. It's the same thing. All right, can I move on? Any other questions on Glucksberg? I have an hour left, so we're going to have to plow through Lawrence and Obergefell. All right, so Lawrence v. Texas is an unfortunate case for many reasons. One of which was never actually even brought. And there's a local connection for you all. Does anyone know the name Chuck Rosenthal? He was a district attorney here in Harris County. He went to this law school. He will not be getting Alumni of the Year anytime soon. He was not a very good DA. He made a lot of mistakes. This case should have never been brought. And I don't care what you think about gays. I don't care. They should have never brought this case because it risks setting a precedent. Even if you support the Texas law, you should never have brought this case. It should have never been appealed. anywhere. And the last step is the district attorney wanted to argue it himself. This was one of the worst Supreme Court arguments I've ever heard in my life. You know who could have argued this case? Ted. How about Ted Cruz? Ted Cruz was our Solicitor General, who you may not like him as a senator. He was a damn good lawyer. He was our SG for Texas. He could have argued this case. He was like, please let me argue this case. Like, no. Chuck Russell thought, oh, this would be good for my politics, right? I'll be a big conservative lawyer. He blew the case so badly. At one point, they asked me in the argument, are gay couples allowed to adopt in Texas? That's an important question. Right? If gays are, if this is immoral, right? Why letting your children? And he's like, yeah, I don't know. He didn't even know. He prepared so poorly. Rehnquist apparently was so angry at this. He just kind of like put his, so the Texas connection is not good here. This case indeed arose in Texas. Let me just play a little bit of the clip. So the case arose right here in Harris County. Let's play this clip so you can see Mr. Lawrence.
Constitutional portions of the Federal Defense of Marriage Act, or DOMA. In this video, we continue our analysis with Lawrence. Justice Kenneth.
In Houston, Texas, police officers were dispatched to a private residence in response to a reported weapons disturbance.
Facts are actually a little bit different. And this is all sort of taken secondhand, but you'll just have to bear with me. So apparently Lawrence was a white guy and Garner was a black guy. And this creates some jealousies. So who actually called the cops? As best I can tell, it's one of Lawrence's partners called the cops because he didn't like Garner and Lawrence being together. So what are you laughing at? He basically said the black guy has a gun. I'm just grossly summarizing. Because he was jealous and he wanted to be with Lawrence. Another gay guy, right? Yeah. This case should have never happened, right? Bowers v. Harwick should never happen, right? That the cops walked in doing a Fourth Amendment search and they saw another guy having, sex with another dude, right? These cases should never happen, but they happen in such weird situations. All right, let me keep playing this.
The officers observed Lawrence and another man, Tyrone Gardner, engaging in a sexual act.
They almost certainly were not having intercourse. They may be doing something else, but it was not intercourse. Okay. So it's not clear they actually violated the statute.
They just
That's Lawrence.
yelled, threw me back on the couch. It's just all of a sudden we're taking you downtown. Their version of the story was that they had found us engaging in sex. They did not search anything to find a gun.
So again, they were called there for a gun search. They were going to look for the gun.
A majority of the court overruled.
And I think what was happening is that, and again, I can't remember the fact exactly. I think Lawrence was moving and Garner was helping him move. And then the other boyfriend got jealous of this. This was just drama, right? This is like the relationship drama that happens a million times a day that would never, ever get to the courts. Except for the fact these two guys were gay. They went to court, and actually Jerry Bernberg, who was sitting in my class last week, the lawyer said, you have to plead not guilty. Because the government said, we'll just dismiss the case. We'll just make the way like, no, we will not take a guilty plea. You can do this? The government can say, we want to move to dismiss the case, and says, we don't want to dismiss the case. They want to litigate this issue. Between Bowers and was it 85 or 86, and Lawrence in 2003, there were no prosecutions for homosexual sex. This was just not done. Even in deep red states, like, we don't like this, but you guys do you, right? We're not going to prosecute this. So this was a test case where they actually had a prosecution where a very poor decision was made by our district attorney. So by the way, Roosevelt started emailing me a couple of years ago. He stopped. I don't know if he's still with us, right? But he's like, hey, Professor Blackman, I saw your lecture. I'm like, do you know what I say about you? Right? It's like, I argued. Laura's like, yeah, I know you did. Right? I never met him. Just he sent me some emails about something else. Here's a very nice guy, but he made a mistake here. Okay. So the case goes to the court. That's what I do. Okay. So Justice Kennedy is in his sort of peak here. And there's a couple of themes. So first off, stare decisis. In Casey, Justice Kennedy had this eloquent elegy, about stare decisis, that we must reaffirm Roe. Yet in Lawrence, they overrule Bowers. In Casey, the court explains that we have this sort of this fundamental right. I'm sorry. In Casey, they say that abortion is not a fundamental right. Yet in Obergefell, they basically say that actually homosexual sex is a fundamental right. And then you have the issue of Glucksberg. Glucksberg seems to say we only protect those rights that are deeply rooted. Whereas in Lawrence, they say, well, we have this new test called the emerging awareness test, where we protect rights based on emerging awareness of liberty. So the ping-ponging is confusing for students because you go from Casey to Glucksberg back to Lawrence. And it's very hard to line these cases up. The opinion begins, Justice Kennedy's very dramatic openings. Liberty protects the persons from unwarranted government intrusions. In our tradition, the state is not omnipresent in the home. And there are other spheres of our lives and existence outside the home that it should not be a dominant presence. Is this a Fourth Amendment case? Probably, right? In other words, they had a warrant search a gun, but then they found them having sex. It sounds like a Fourth Amendment case. It's not a Fourth Amendment case. The court says freedom extends beyond spatial bounds. Okay. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. The instant case involves liberty of the person, both in its spatial and in its more transcendent dimension. Again, liberty, this case involves liberty of the person, both in its spatial and its more transcendent dimension. Okay. So Chanel, the first question I want to ask you, is this a due process case or is this an equal protection case? What actually is the case here? What clause of the Constitution the court rely on? Why is it not equal protection? Right, but why couldn't this be a protection case? It's actually Justice O'Connor's point of concurrence. Why is this not a protection case? So is O'Connor wrong?
Like, I think.
Okay, this is like gross. If a man and a woman engage in sodomy in Texas, was that a crime?
Yeah.
That's what O'Connor said, it didn't make sense.
Brenda is correct.
Men and women could do it, but.
If a man and a woman engage in sodomy, anal sex, right, in Texas, that was legal. If two men engage in the exact same act, well, it's not the same act, but the same act of anal sex, it's illegal. This was Justice O'Connor's point. In Bowers, curiously, the law in Bowers banned sodomy full stop. So anyone could engage in oral sex or anal sex, full sodomy, right? But the Texas law only prohibited homosexual sodomy of people of the same sex. So O'Connor says this is form of sex discrimination. And what's the standard for sex discrimination? Some sort of intermediate scrutiny. This is from Frontiero, right? VMI, Virginia case. I'll get back to Kennedy in a minute. Let's talk about O'Connor for a moment. Right, so Justice O'Connor would apply intermediate scrutiny. So with intermediate scrutiny, you must have what they call an important state interest, right? Lauren, what is the state's interest to ban sodomy? Homosexual sodomy in particular.
Health and or moral,
Okay, be more specific.
the moral interests of the state.
So what's immoral? Why?
If it was the same that,
Why was that considered immoral?
was it that it was like the health concerns?
Not really. This has been long for health concerns. No?
Was it necessary to impose their moral on like the applicant?
Yes, ma'am. Yeah. So it's what's often called moral disapproval. Why is this banned? We think it's immoral. Right? The state has lots of laws that are premised on morality. And Scalia makes this point in his dissent. So why do we ban incest? Say, oh, genetics, recessive traits, right? We didn't know this when they were banned, right? Incest has been illegal longer than we knew about genetic traits. And in fact, if that was actually the rule, people should get blood tests where they get married, right? Some countries actually have to, right? Two people have carried recessive genes, maybe they should get married. We're concerned about this, but why do we ban bestiality? If a person owns a dog, why can't they have a relation with a dog? Sounds gross. Morality. Why do we ban obscenity, right? Why can't people engage in obscene acts? Why do we ban animal cruelty? I know you all love animals. Person owns an animal to chattel. Why can't they engage in abuse of the animal? Morality. Almost every facet of the legal system is based on some conception of morality. But Justice O'Connor says in Lawrence, this is actually the most important part of the opinion, that moral disapproval of gays is not a legitimate state interest. That the state cannot use the law to just disapprove of others. It denies them their dignity and autonomy. Same thing for abortion with Casey. To use the law to signify, why we ban abortion? It's immoral. We shouldn't do it. What the O'Connor says here in Lawrence is that the states cannot use morality to demean others. That is not a legitimate basis. Scalia said this is a radical shift in our legal system works. That for forever, for eternity, governments have relied on morality in passing laws. But what Lawrence and I think it's called Windsor did was they decoupled law from morality. So the government can only use morality in passing laws that demeans people and their dignity, so that your lifestyle is not worth protecting. Everyone see what O'Connor did. Again, the Kennedy opinion, we can talk about this, the language and the dignity and liberty, but O'Connor actually is kind of a natural lawyer, and he's trying to actually put some teeth in it. No one joined her, by the way. She was all by herself. O'Connor's in a weird spot. She joined Bowers, but she wouldn't vote to rule Bowers. So the Bowers is different. That was about any act of sodomy, but this one's only about sodomy for people of the same sex. So we're going to see what O'Connor says there. This idea of moral disapproval is not a rational basis to pass a law. So she's right. What about gay marriage? Anna? If O'Connor's right and you can't impose laws based on morality, then what possible basis is there not to recognize gay unions, to recognize straight unions? There's none. O'Connor said, this is not about gay marriage. And Justice Kennedy said, it's only about lawfully recognized marriages, but Scalia's like, do not believe them. So he said, do not believe them. They couldn't be believed. There was no way to stop the train to same-sex marriage once you started this. Once you said that there's no rational basis to have a law based on moral disapproval, there's no reason to not have gay marriage. The entire premise is we think that straight marriages or traditional marriages are better than opposite-sex marriages, right? That's the entire basis of the law. think that these marriages might be harmful to society, harmful to children, and so on. That's not enough. So the train that started with Casey and Romer and Lawrence was going full stop to get to Obergefell. There was no way of stopping it. It was like, it was sort of a weird thing to sort of teach, because we knew where it was coming, we knew where it was going, just we know when it was gonna come. That's right. Again, someone said Scalia and Kennedy. Scalia was in this 30-year cat and mouse game where he's just kind of just chasing Kennedy, saying, look what he's doing. I'm telling you, listen to me. I'm Cassandra, listen to me. And Kennedy would never respond to Scalia. He just would never acknowledge it. He'd just sort of live in this old bubble.
So like, they're pretty much dropping the veil of morality in the sense of making law. It's just like, how do they not see that as a danger? You know?
They saw it. Well, I'll tell you exactly why. Because they thought they'd always be in power and they'd be deciding what morality is. It's very easy to do this when you're in charge, right? They thought that Justice Kennedy would be in the control and he has his own sense of morality and everything will be fine. They never anticipated what would happen if you give this power to a conservative court. They never thought quite that far ahead. They really didn't. They truly didn't. After Roe and Casey and Obamacare, thought, oh, we're good, right? So it will never happen that conservatives will be in charge, because judges will always sort of bend to our will. But they thought that, and then it didn't. Right? It's really a remarkable story of when you're in power for so long, you don't think what happens if the other side uses that power. You know, it's sort of a contemporary thing. A lot of the power that Trump are exercising, a power has been established before. And they thought, oh, it's fine, we use it, but now the other side's, oh, crisis, right? Whenever you think of someone exercising power, think, what will happen if my opponent uses the same power, whether it's a judge or an executive? Always think about that. So I'm going to get the O'Connor opinion, Lawrence. Let's go now to Justice Kennedy's opinion. Now, Justice Kennedy does not talk about scrutiny. He never talks about scrutiny. He never says intermediate, never says strict scrutiny. He just didn't care about scrutiny. Legal test didn't matter to the guy. It didn't matter. And I think he doesn't even call it a fundamental right. I don't think he uses the label fundamental. Maybe you can check this. I don't think there are fundamentals in there. Instead, he speaks about this right of intimacy and dignity. Wait, didn't Glucksberg just say we define levels in a very careful, narrow sense? Whereas Justice Kennedy defines it very broadly, about dignity and autonomy. So how do you then reconcile Glucksberg with Lawrence? And the short answer is you really can't. I mean, maybe you can, right? But it's actually very hard. Justice Kennedy would get to this issue more in Obergefell. We'll talk about this in a few moments. But basically, Kennedy says, history and tradition are good as a starting point. That's not the bounds of our judgment. We develop what he calls an emerging awareness. An emerging awareness. That is, we today can see truths that people years ago could not see. That the framers of the Constitution didn't understand liberty in all of its manifold dimensions. They couldn't know the liberty that we know. We know what they didn't know. And we have to then apply this liberty for all, not our own morality code, the court says. It's the exact opposite of Glucksberg. Saying we don't know, I'm sorry, they didn't know, but we know better. History and tradition are good to start, but we can go on our own. Oscar? In what way?
I remember what the liberty safeguard is liberty in the social organization requires the protection of law against people with tremendous health, society, safety, and law. But I thought in there's a presumption that they do have the right to regulate morals.
It's hard to reconcile footnote to Michael's question, or someone asked footnote 4. No, Bobby's footnote 4. The entire premise of footnote 4 is we let society judge for itself what to do, unless there's some sort of enumerated right. This just blows out of the water, right? if you have told the neutral court that you can't regulate morality, that would be shocked. Right? West Coast without, we protect women from poor wages. That's morality. Almost every law passed is based on morality. And really, they say more. They say it's almost bigotry. That to reject the intimacy of these couples is to be done out of hatred and animus, and not a sense of what's morality. It's to recast basically all morality as bigotry. That's what Justice Alito makes point in the Obergefell dissent.
Would you say that the overarching power at play here would be that they've taken all sense of moral regulation from the legislature and put it in their hands?
Justice Kennedy did exactly that over the course of decades. He literally decided, who could be executed, who cannot be executed, who could have sex, who cannot, who get married, who cannot. He would decide all these issues himself. And he would do it with these languages like dignity and autonomy and transcendent dimensions. This was the state of ConLaw for 20 years. I'm sure there are. Yeah, I don't know, maybe. Yeah.
So Lochner was about dignity and about.
Lochner?
No, I'm saying theoretically, like, I don't have to, like, if it
The
was
dignity of the
Lochner-
bakers, why can't, the butchers, their dignity of slaughtering animals. I mean, again, people spent decades trying to figure out Justice Kennedy, and I think the answer is there was no there there. There was no law there. It was just, he was deciding each case. He had a soft spot for gays and lesbians, but he didn't have as much soft spot for assisted suicide. That's it. Don't work too hard. But don't try to line up. I mean, Justice Kennedy says, while the Glucksberg approach may be appropriate for physician-assisted suicide, it's inconsistent with our case involving marriage and intimacy. You don't say. Right? Yeah, it is. He's admitting Glucksberg's not consistent. Right? He says loving does not ask about a right to interracial marriage, is by right of marriage. But the case was clearly about marriage because it was illegal to have children outside of marriage. So again, we'll just more do to Obergefell in a few minutes, but I think you have to see Justice Kennedy as kind of, he's not trying to make sense of precedent. He's kind of just plowing forward. Say there was a struggle would mean that Kennedy lost. He never lost. Not really, because he didn't care about assisted suicide. He basically limited Glucksberg to assisted suicide in Lawrence. Again, Kennedy voted with the majority in Rage, with LC Rage. Why? Apparently he had a loved one who was a drug addict, and he felt he didn't like drugs. So okay, he banned marijuana. Truly, this is how you reconcile. By the way, Scalia apparently called the drug exception to the Commerce Clause for Scalia. He want people having pot. I think Scalia is a little more principled, but Justice Kennedy was deciding each case based on its own, based on what he thought about. Yeah, he retired 2018. No, he was like that from the outset. From the outset, if you read his readings in the late 80s, if you look at his confirmation, he was speaking of dignity and liberty as confirmation. He believed this from the outset. He never changed. This is who he was, and he put in the Supreme Court anyway. I mean, he said these things in low court opinions. It was not a surprise. A friend of mine who clerked in the court, so Kennedy's window would be across here from the Congress. And he would look at us and say, "What were you thinking?" He'd be screaming at his window at Congress. "What were you thinking with the statute?" He said, "What did you mean by this?" And apparently he's writing a 2-part biography, which I have no interest in reading. Right? Just zero interest in reading. His opinions doesn't matter anymore. Right? In other words, like with a judge like Scalia or Robert Jackson, you read their stuff 100 years later because what they write is timeless. Right? John Marshall, Joseph Story. You read this stuff 100 years later. No one will read Kennedy's work after he's off the court. It doesn't matter anymore. Right? Again, we are like literally like purging him from our casebook. It doesn't matter. Randy was talking yesterday, like, yeah, we can cut this, cut that. Just his work mattered because he was the 5th vote, and for no other reason. Yeah. 5, yeah. All right. The Scalia dissent, or actually the Scalia dissent in Lawrence was especially vicious. He basically says you cannot trust the majority. They are obviously trying to put us in a road towards same-sex marriage. There's no sort of doubting it. The court overrules Bowers and never really acknowledges the stare decisis principles from Casey. The court applies strict scrutiny, but never says it's a fundamental right. This is not rational basis scrutiny by any standard, right? If this is rational basis scrutiny, then nothing is. Oh man, I'm almost out of time. All right. And Justice Thomas calls this an uncommonly civil law. He brings in the Stewart dissent from Griswold. All right. Questions on Lawrence? I have like 10 minutes for Obergefell. Not good.
Those Kennedy eras.
The theme would be one of dignity and autonomy. That how do we have laws protect people's dignity and autonomy? That'd be the theme. But it always went in one direction, right? It kind of, you knew which way cases were going. Yeah. Oh yeah, Scalia's and Roberts too. Scalia and Roberts basically compare Justice Kennedy to Dred Scott and Tawney. They're using substantive due process to try to settle national controversy. I mean, what was Dred Scott? He says, we use substantive due process to settle national controversy. What was Casey? We use substantive due process to settle national controversy. Oh yeah, Scalia compared Dred Scott to Casey, big time, directly. Scalia compared, and what did Roberts compare Obergefell to? Two cases, Dred Scott and Lochner. It's like in the same breath, John Roberts says, you're Lochner and you're Tawney in one. Right? I told you Lochner's where everything is. It's like the center of their thought. They can't escape it. This terminal velocity they can't get out of. So, Obergefell, let me do this quicker than I would like to. Maybe I'll try this one. What is the state's interest in marriage? Right? What is the state's interest in marriage? Yeah.
Like they don't want to be like make fun of and stuff.
No, not exactly. The first time for everything. Yeah. Be more specific. Anyone can reproduce, but why is marriage important?
Tax.
No, not tax. What? Be more specific. What's the relationship between marriage and reproduction that's important? Paulina, save us, please. Family. Tell me more. Why? Who's they? Good. All right. So you should ask him, why does the government have marriage? Like, oh, love. No, it's not about love. It's not about taxes, right? It's not about population. It was the belief since time immemorial that the strongest foundation for raising children, having society, is a family, right? A single parent has a harder job than a couple. This was certainly true in the time women couldn't work, right? Marriage has existed in every civilization in Western history, right? Civilization never met how they have marriage. Now, to be sure, there was polygamy, multiple marriages. If there's actually a right to a deeply rooted right, it would actually be to polygamy, right? Marriage was built as a way to promote families, right? That the view was the most stable way of having families was to have two parents, a husband and a wife, a mom and a dad. Okay. Yeah.
Do you think that, like, just on that polygamy one, would a case like that ever go up, or has a case ever go up?
Oh, if you read a Berg, like, we're not talking about polygamy, don't want to talk about it. There have been challenges and the courts have run away. So we're like, oh no, we're not going to talk about that. It's cowardice, right? If you actually want to take a Obergefell seriously, there's a right to polygamy. Who are you to say that three people can't get married? Polycules, right? Who are you to say? Don't be so judgy.
I mean, yeah, because it's like in other religions or in other cultures.
Yeah. In the Abrahamic faiths too,
Yeah,
right?
exactly.
My good friends from Utah, right? They had Utah was admitted to the Union on the promise of not have polygamy. Right? That's in their state constitution. They cannot have polygamy. Islam, well, yeah, there are many civilizations in the world that have multiple marriages. But I want to stay on the thread, right? I got 10 minutes left. The argument is that marriage was considered a basis to have responsible procreation. That is, it channels a natural act, which is sex, into children who are then cared for by two parents. Is that a rational basis by which to structure society? Absolutely. Right? It wasn't about any animus towards gays and lesbians. It was about traditional belief. What does the court say in Obergefell? That there's no rational basis at all. That limiting marriage to people of the opposite sex is a form of animus, hatred, bigotry to gay couples. It demeans them. It deprives gay couple of their dignity. And it deprives the children of gay couple, whether adopted or otherwise, of their dignity. Right? This is where Justice O'Connor's opinion from Lawrence really kicks in. The idea is that moral disapproval of homosexual relations is not a rational basis. That's all you need to know about this case. Once you say that, it's easy, right? If the government lacks any rational basis to enact these laws, then they're not valid. Is this about text, history, and tradition? No. This is about an emerging awareness. There's a debate going on. States are experimenting with gay marriage. But the court says the people do not have to wait any longer. They do not have to wait for the fundamental rights. So Obergefell is both equal protection and due process, like a little bit of country, a little bit of rock and roll. It's a little bit of everything, right? It's a fundamental right of gay marriage. And it's a violation of protection to deprive gay couples of this right. It's kind of like twisted, right? Both equal protection and due process sort of work together in this case. Justice Kennedy writes, the Constitution promises liberty to all within its reach. A liberty that includes certain specific rights that allow persons within the lawful realm to define and express their identity. The petitioners in this case seek to find that liberty by marrying someone of the same sex and their marriage is deemed lawful. Okay. So again, the actual analysis here is not that hard once you accept Lawrence. Once you accept the premise that states don't have any rational basis to treat people differently because they're based on morality, this case is easy. This is not based on history and tradition, right? When Meyer and Loving spoke about the importance of marriage, they were speaking about reproduction, right? That's what they're talking about. When the Loving couple had kids, they were basically illegal in Virginia. They couldn't be unmarried with children, right? They were bastards, basically. But they say new dimensions of freedom become apparent to new generations. And the courts are able to recognize these evolving trends. And they cite the cases, Bowers, Romer, Lawrence. All these cases establish this principle that there's no rational basis to treat them differently. Scalia, his prediction at least, was right. The court says, when new insight reveals discord between the Constitution, a claim to liberty must be addressed, that we will embrace it. This was often called living constitutionalism, the idea that the Constitution evolves and changes with time, and then judges the oracle to figure out what those changes are. It's the exact opposite of the history and tradition approach from Glucksberg, the exact opposite. Okay. I'm running out of time. Questions on the majority opinion in Obergefell? Yes, ma'am. Well, you're asking when after, right? In the immediate aftermath of Obergefell, if you're sitting in my classroom in 2015 or 16, I would have told you history is dead. So I told you. And I think it was incorrect at that time. I'll tell you that today. The court, though, does not overrule Glucksberg, and this is the key point, the key insight, right? This is the court says right? Glucksberg is inconsistent with a case on marriage and intimacy. Kennedy writes, if rights were defined by who exercised in the past, then received practices could serve as their own justification to deny the rights. In other words, if rights were denied in the past, keep denying them. Justice Kennedy says, no, we cannot do this. He says, rights don't come from ancient sources. They rise from better informed understanding of how constitutional imperatives define liberty that remains urgent in our own era. He's saying we, the court, can define what those rights are. We can see, we can look, we can discern in the ether what rights ought to be, and we will determine them if they're fundamental. This is repudiation of everything footnote 4 stood for, right? This is repudiation of Lochner. This is Lochnerism at its highest. This is an emanation of penumbras. We define what these rights are, not you, the people. Well, it depends who you ask. I mean, people celebrating when this case came out. People on Discovery Green getting married, right? So this is actually one point that Roberts says, you can celebrate the marriages, but recognize the challenge of the constitutional law. Actually, Jim Obergefell came to Houston in 2016 or 17. I can't remember what year it was, and he did an event. I saw him speak, and he was thrilled. So people like this ruling, right? To be sure, there are the people who benefit from it, but the actual analysis itself changed the way the court decides ConLaw in very significant ways. Yeah, somewhere there.
It's all that is taking schools doing the opposite of whatever they say. It's like individuals do not await legislative action before asserting a fundamental right, which is what Scalia literally just said.
Scalia said you have to with the legislature. In fact, by the time Obergefell decided, marriage was a 50-50 issue nationwide. Had I think give it another 5 years, I think most people have had gay marriage, and 10 years for sure, I don't think every state would have had it. So it was an issue where there was debate, and people were discussing it, and the court cut short the debate. They said, no, we can't debate anymore, it's done. It's basically like Roe for abortion. Like, you cannot debate this.
I know this is a question for Wednesday, but is it fair to say that Dobbs created fundamental rights that are made through the legislature, but if they're trying to say something that's like not a legislative right, then they go back to
so people often always say fundamental rights are not able to debate. You should not be able to debate my rights. But that's the question: what are the rights in the first place? Where do these rights come from? Dobbs, whatever I say about it, brought issue back to the democratic process. Just this week in Texas, they're debating a new bill to create protections for abortions. This may could have never happened a couple years ago. But that is, people now can debate these issues. Okay, let me move on. I only have a couple minutes left. I want to finish on time. Again, the court says we don't need to wait. He says dignitary wounds cannot be healed with a stroke of a pen. You can't wait for the legislature to act. The courts must act first. Fundamental rights may not be submitted to a vote. They depend on the outcome of no election. Okay. All right. The very last paragraph. The court, Justice Kennedy writes this thing. This actually was printed, I think, in a greeting card for Stames this way. I'm mostly joking, but no. It says, the court says, no union is more profound than marriage, for it embodies the highest ideal of love, fidelity, devotion, sacrifice, and family. In forming a union, two people become something greater than they once were. They ask for equal dignity in the eyes of the law. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's old institutions. So, yeah. All right. There were several dissents. I think there were 4 separate dissents. Roberts, Scalia, Thomas, and Alito. They all made sort of similar points. Roberts was like a man on a mission here. He actually read dissent from the bench. I don't think he'd ever done that before. He says, this is Dred Scott. This is Lochner. Right? I don't begrudge people celebrating, but this is a government of law, not of men. He says 5 lawyers, not 5 judges, 5 lawyers have ended the debate and acted their own vision of constitutional law. There's no basis in the Constitution or the court's precedents. This is Lochner. He cites Holmes. He cites Harlan. This is not what the court ought to be. Okay. Scalia is like the biggest "see, I told you so" ever. He's like, I told you so. You guys don't listen to me, right? You don't listen to me. I told you this happened decades ago, and no one listened to me. By the way, Scalia died about a year and a half later. He did not live much longer after Obergefell. This is kind of his last swan song. At this point, Scalia got kind of bitter in his later years. He just kind of got angry. He's like, man, I'm so pissed at you guys. I can't do anything. And meanwhile, his death probably led to the reversal of Roe years later. Had Scalia not died then, I don't know if Trump would have won. I'm not sure if Roe would have been overruled. So it's just the weird sequence of events, how things turn. I called it the inside straight, how things had to happen in a row for Dobbs to happen. Justice Thomas makes a point that due process is not about liberty with rights. It's about restraint, that the government can't control you, that there are no substantive due process rights. So he rejects it altogether. Alito says that, this also harms religious liberty, that now people who hold traditional views on marriage will be shunned from society. It's can't be the argument, Woody University has to give housing to a gay couple now. And the government's like, oh, we don't really know. Yeah, I haven't thought about that. Okay. Middle left. All right. Questions on Obergefell? I'm sorry I flew through that one so quickly. It was not intended, but I might catch a little bit more on a class on Wednesday, but we have a lot ahead of us. The Dobbs case is big. Yes, sir.
So Lochnerism, really cool when it supports you, really not cool.
Everyone loves Lochner when it's on your side, except when it's not on your side, then you hate it. Let's go ahead and end the class. Anything else? Thank you all so much. Have a wonderful day.